Thanks a lot, and thanks a lot also for the invitation. It has been way too long. The Script Center started its life in 2004, so we are technically speaking older than you. But the way you've worked here, especially with informatics, the sort of interdisciplinary work that everyone always asks for, but very, very few people do, has been exceptional. And it really, really has. From starting a journal to really working very substantively with informatics in ways we didn't quite achieve in Edinburgh, I would say. We are still very much focused in the law school, even though some of us are not lawyers by training. I was sort of almost worried when you started your introduction, because when I did the last update of my slides, I realized that the content moderation might fall out of it. But I still have quite a bit to say, and there's also quite a bit on content moderation I will be able to say. The title says trust us for we are legion, in bracket Habermasian perspective on majoritarian content moderation, blockchain and the law. You will all be aware of blockchain. I will say a little bit about the technical aspects just because I wasn't sure what type of audience I'm going to get. But one thing that is very obvious in the working environment of blockchain is the idea of something that looks like a majoritarian decision-making system. So you vote, or the different minors or witnesses or however you call them vote. And if there is a majority, then that becomes the next block in the chain. It's a very, very simplistic system. And that has seen by those who were in favor of the technology from a very early point onwards as one of these huge advantages over a centralized system where you typically have just one guy saying what's going to happen, or a group, a committee of people, but a centralized group that is not responsible directly towards the majority of people who are affected by their work. However, it is a majoritarian decision. That is, the mere majority is enough. And that also becomes a problem for cybersecurity, the feared 51% attack, where someone manipulates the system in such a way to just get this very, very slight majority. But also, I would say, from a human rights perspective or a legal perspective, a real problem. Democracy is great. I'm all in favor of democracy, don't get me wrong, but only if it is constrained by law. And one of the constraints of law is that the majority can't always do what it wants to do, that there are certain rights of the individual that trump even very strong majorities. So we get constitutions which have a qualified majority requirement when you want to update them. The US Constitution, for instance, has a very complicated mechanism to create updates. You have constitutions that claim that there is no way to change at least the human rights part, like the German Constitution, even though you could wonder whether you can change the part that says that there has to be no change of the human rights part through a qualified majority. Slightly different story for a different day. So in the blockchain environment, one of the difficulties for me always was this idea that we are now trying to build a society where pure majorities, the democratic principle not constrained by the rule of law, reign supreme. And a little bit of what I'm going to talk about, but not as much as I had hoped, is exactly on that issue. If you followed Habermas' criticism of the modern digital world, his main concern was the blurring of private and public. His model of the competent sovereign free discourse was always meant for the public sphere and leaving private citizens living their private life in parallel. How does this work in an environment where you have Facebook, X, all these systems where private and public fall into one? A problem, according to him, but I would say it is not the main problem. The main problem really is the question, what is the role of majorities? And there, his idea of a deliberative discourse, where you do not just vote on a whim, but after a process that can be scrutinized, accounted for, leveraged. That is, I think, for me, one of the things we need if we want to have a blockchain world that really abides by the standards that we hope. Now, quite a lot of this work, well, first I should say here, quite a lot of this work, really, this paper, came from me and my two research assistants, Adrian Lee and Amanda Horczyk, which I should mention here. Without them, it wouldn't have been possible. So pretty much everything that you hear that is right, convincing, and true probably is either Adrian or Amanda. I'm primarily responsible for the inappropriate jokes. So just that you get an idea of what you're going to get. I got these two partly because we are all part of, or we are part of Decade, the center for the decentralized digital economy. And yes, I'm perfectly aware of the irony of this name. We chose it in a way deliberately because we felt that even though decentralized digital economy has huge opportunities for us, getting simply rid of the central authorities is not necessarily a good idea. So we set up a center that involves the University of Surrey, the computer science school in the University of Surrey, and their business school. And then we have the University of Edinburgh, which contributes design informatics, a school that sits in between the hardcore programmers and the humanities people, and me as the one lawyer in that bunch, trying to maintain the type of legal compliance that we also need. If you look at the mission of the center, and especially with the emphasis by me, in our increasingly decentralized digital economy, everyone can be producer and consumer of goods and services. However, these dynamic peer-to-peer markets are all underpinned by centralized digital platforms, and users rarely have a say in the governance of their decisions. Just look at the exodus after Elon Musk took over. There wasn't a way to change as user what was going to happen. The only way to have any say was essentially to move to blue sky. And that type of disempowerment, we think, is one of the shortcomings of the traditional centralized digital economy. And so we try to explore how emerging data-centric technologies such as DLT, blockchain, and AI could enable a fair and safe future digital economy. And for me, fair and safe doesn't work without the law. You can try to replicate a lot through mere computational functionality, but as we will see also in the talk, there are limits how far you can go with that. Now, I'm also old, as you can see and hear. I used to have a ponytail right up to 2010 or thereabouts, I think. And increasingly, I feel like an old man shouting at the clouds. One of the things I increasingly often have to say is, this is not new. We had exactly that discussion when I was young, and then it was new, despite what all the old fuzzy people were saying who claimed that this was also not new then. Andres Guadamus wrote his PhD with a little bit of input by me and published it as Networks, Complexity and Internet Regulation in 2010. And at that time, he made the argument that the complexity of the internet and its self-organizing nature would be a serious problem for any type of effective legal control. So the fact that it was decentralized, the fact that it was complex, the fact that a lot of things on that internet will happen automatically was a reason to assume that laws would not be efficient in its regulation. I don't think he would write the same book today, because what history has told us was that very, very quickly, even in this, in theory, decentralized internet, centralized structures re-emerged. We just got different intermediaries. We got Facebook, we got X/Twitter, Blue Sky, however you call them. And they very quickly became also the focus of regulation and legislation. Sure, there are problems. There are always problems when you try to enforce law across borders, when you deal with a global economy, but they are not conceptually new. Conceptually, we very quickly realized we are back where we started. Now, these days, we get token economy, how the Web3 reinvents the internet. And pretty much similar claims are made. That now in the Web3, we'll finally have decentralization how it is meant to be. That is without necessarily strong, centralized, potentially abusive people running it. A mixture of digital distributed ledger technology, blockchain, plus AI is essentially going to achieve what we in 2010 tried to achieve, but ultimately failed to do. And this is partly the reason why we started our center. The recognition that decentralization and AI taken together as Web3 were posing significant new problems and opportunities that require both a technological perspective and also a legal perspective. While the center was running, and I should say we are now on a no-cost extension, so we are still working, we just don't get any money for it, until we will finally present all our findings at a conference in March next year, and then finally wind us down. We started at the heydays of the NFT, shortly after COVID was over. It took us exactly 4 or 5 years to get where we are. And one thing that happened at the same time, but not as part of our plan, was 2 government consultations. The first one on the ownership issues of digital distributed ledger technologies concerned the question of ownership of digital assets. Can you own a file? Can you own an NFT? Can you own a Bitcoin? Can you own anything that does not exist in physical form? It's quite remarkable for me, and in that sense I'm probably even older than I look, that we managed to build a digital economy without ownership, largely. Sure, there's ownership in the physical computer, there's ownership in the server, but quite a lot of what we consider to be the digital economy works without a notion of traditional property law. That doesn't prevent people to talk about ownership, but if you probe it from a legal perspective, it's not what we really have. Instead, we have IP law, we have data protection law, we have contract law, and the combination of these different legal regimes do not, in our view, really fulfill the same social function that property law was able to fulfill. So we were quite happy to see that at the same time, both England and Scotland, England leading, Scotland following, as so often. I get filmed here, don't I? Okay, yeah. Scotland, wisely waiting to see what others are saying before moving in, started their own consultation processes on ownership of digital assets. The English proposal, by now more or less at the final stages, it will become a law, but it will be a very, very short law that essentially says, let the court sort out this mess. Scotland had a slightly different problem. In Scotland, we do not get the volume of cases that benefit the English judiciary or the English legal system. So we had to find a way to reassure investors that their digital assets were as protected as those in England or anywhere else in the world. The US is also moving to full property recognition of digital rights. So we also started a consultation that is still ongoing. I will talk to the Scottish Parliament in 2 weeks, and that is just one of the very many small steps that will be needed for this. But unlike the English model, we are likely to see a fully regulated environment which goes quite a lot into the detail of what type of technologies are acceptable, what the legal consequences are, and so on and so forth.
I know that there will be questions afterwards,
yeah.
But, because there are more topics. Didn't you have cases of succession to digital assets? Isn't this driving force behind this public attention? This is what we have in Europe.
Yeah. We have. We had some English cases on that question, but they were all resolved without determining the status of the actual asset. There were always ways around, workarounds that led to perfectly fair results, but were very specific to that case. What we didn't have was a reassurance that you can pass on cryptocurrencies to your heir. For instance, they just used contractual remedies instead. And we don't have them in Scotland at all, to the best of my knowledge, and not fully litigated. It's a huge concern for lawyers. Majority of queries I get, and I always have to say I can't tell you because we don't have case law on it, from Scottish law firms is, my client died, they have crypto assets, can they pass them on? And yeah, an analogy to the English solution, typically I would say, yes, you can, but don't call it like that. There's another interesting aspect to that, by the way. I think what Scotland is now proposing is pretty much how Austrian law is supposed to work. If you look at the text of it, because it doesn't make the distinction between digital and non-digital assets, unfortunately, Austrian judges looked way too much over the border to Germany and interpreted their law through Germanic eyes, and German law very clearly denies ownership in full ownership in digital assets. So we might see a realignment here of the old alliance between Scotland and continental Europe, and England moving into a different direction. At the same time, we also had a consultation on AI and copyright. That one was more recent, starting really last year, driven by massive concerns amongst especially the creative industries. What will happen with our works, with our lives? We will all be aware of the cases of actresses getting their voice suddenly coming back from internet speakers, telling drivers in their car whether to go left or to the right, or things like that. So a huge concern within certain groups that their work was without any rewards used for essentially the benefits of ChatGPT and similar systems. The UK approach has been ambivalent, I would say, to put this mildly. On the one hand, arguing that we want to be investment-friendly, innovation-friendly. We do not want to go down the AI Act model, for instance, that continental Europe has, but at the same time pointing out, and very correctly, that the creative industries are probably more important for us than the computer industries. So trying to find a balance between these two became one of the challenges for the government. And one way to deal with the challenge is to have a consultation, because then time will go and you might find out what happens anyway once that period is over. So these two were running in parallel. And I'm just saying a little bit about two of them. The first one, ownership of digital assets. You will be aware of that. It's amazing how fast things move, isn't it? This was 2022. This is just 3 years ago when someone paid 69.3 million for an NFT. I don't think they would make that amount of money today. I honestly have my doubts that the retail value of NFTs kept its space. There was a famous case in the US where, in a divorce case, the husband decided and wanted to keep all the NFTs they had and left the house, the car, and all the physical assets to his wife, only to 6 months later realize that he had a lot of PDFs with receipts of buying them. He wanted the court to overturn the original decision, but the court said quite rightly that he had fully agreed into this, and the law's role was not to prevent idiots from doing idiotic stuff. But this was a huge thing back in 2022. And other industries very quickly followed. That's a digital aspect of traditional museums, art galleries. They all felt there was something in there. And I mean, despite my mocking comments, I think there is a very real need for artists to get something in the digital world that replicates ownership. It just wasn't going to be NFTs and essentially a receipt for having bought something, but nothing else. And finally, to mention here, Alexandra Olyankova, a Ukrainian tennis player, who sold a small part of her arm in an auction, and the winner is now allowed to put a link or any link to an NFT or an NFT in there, as long as it is not derogatory, advertisers gaming, or any of the other things that could get her into trouble with the tennis association. So that was a huge thing just 3 years ago. And again, it's important for me to emphasize that this was just three years. NFT still exist. Ape Yacht Club still is seen as a major player in that field, even though they now face problems with the law as well. But what we think is essentially, firstly, or what definitely transpired was firstly, the idea of running this without the involvement of the law, without the involvement of centralized systems was mistaken. And the idea that blockchain on itself would prevent crime, would ensure everyone was getting exactly what they wanted, very, very quickly turned out not to be the case. Here we get one example simply on the amount of fraud that you are getting with blockchain, with NFT. And here a rather sad story of Loish claims her art. She's a very, very good digital artist, only to find that many of her images suddenly popped up, minted on blockchain by people she had absolutely no connection to. And all the attempts to get the exchange platforms to revoke this, to change this, failed. So OpenSea in particular was by far not as helpful as we felt could have been. So that is essentially the problem situation on the digital technology side. It responds to a very acutely felt need by artists and other creatives. There is definitely something they deserve to get, where the law should help, but they are not getting it in the form that they had. Now, with AI, situation is, again, you will be aware of that, complex. We get the performer strikes in the US, especially low-ranking actors fearing that their one contribution that they made will be replicated by an AI, will become a fungible entity that can be exchanged between different studios. You've played the second orc from the left once. Well, we can replicate you 1 million times for this specific film, but also for future films. So you get a concern that this part of human creativity can be replicated by AI. You get the same with music. The idea that musical styles can be learned by AIs, leading in the UK a couple of musicians to copyright, to create a silent CD, something where that you only hear a little bit noise in the background from the studio, because they wanted to show, if you go ahead with this, if you allow these generative AI models to grab our work without compensation, that will be the end of us. We won't be able to work and create under these conditions. The reason that I brought up the 2010 book by Andres, also because of that, because we had exactly the same creative right holders versus technology dispute back in 2010. At the time, it was streaming services. They were seen to be the definite end of Western civilization as we know it. And what very quickly happened after people voiced their concerns was a license model. And I think for most rights companies, YouTube is now one of the main sources of income. So a bit of a warning here, maybe not to emphasize it too much. AI is not art, again, from the American strike. But also this, as a sort of second element of this, the police in many US states, if you go and complain, will put on somewhere in the back the radio and play music. Any ideas why? Apart from obviously calming you down as they do as responsible police officers. Any thought why the police might be really, really keen on having Beyoncé playing in the background when you come in to complain about the treatment you received from them?
Maybe Beyoncé is not the worst thing that they can play.
Beyoncé is actually quite good. Yeah, I would totally agree with that. I mean, they can play actually, but still, partly because Beyoncé is so good, it works particularly well. What they try to prevent is that people make a recording of the interaction on their smartphone and upload them on social media. Because in most social media platforms, also because of the Digital Services Act, for instance, and similar legislation, will use an AI to spot infringing material. So they simply hear in the background Beyoncé and decide as an AI, oh, that can't be right, that must be wrong, and intervene. So you get a AI enforcement of police powers, essentially, which was never intended, which is not how the AI is supposed to work, but spotting the difference between something being just in the background and being in the foreground, parody, all the other exceptions that IP law creates is really, really difficult for automated systems. So we get a massive over-enforcement of IP on platforms like YouTube because of the AI moderators. So these are the two aspects I think we need to keep a bit sort of mindful when we are discussing both the ledger technology and the AI world. The danger that even though you have very, very good intentions initially, you immediately overreach as far as the law is concerned if the laws are not in line with that. So what do we do with that blockchain and AI in a ledgered world? This is just a very brief reminder for all of you, the different layers that we have in a blockchain environment. Layer 0 is the one that simply provides the hard technology, again, similar to the internet as we know it, or the Web 2 infrastructure. Layer 1 and 2 sort of belong together. Layer 1 is the interesting one. It's the implementation layer. There is the blockchain mechanism, the consensus mechanism implemented, the thing that decides that it is really the majority of votes that will eventually count. Layer 2, I only mention it here because it is a different layer, but its main function is to emphasize or make more explicit what happens on layer 1. And then you get layer 3, the application layer, where the engineers and companies, the platform founders, are then able to build stuff. But the important thing is what they do on layer 3 is dependent on what happens in all the other layers. That is non-negotiable. That is how the system works. And they can then try to build something funny on top of it. Blockchain and AI, to bring these two consultations together, I think are essentially about the following things. How can we reassert control over our personal and non-personal data in the digital world? What are the mechanisms that we have for me as an artist to say, this is really mine. I can prove this is mine and I want the rights that come with it. Or this is about me as a person. Please do not use it in the way you are using it to bring in the personal data. And that is the same for blockchain and AI. It doesn't matter whether you are trying to convince OpenSea that one of the minted NFTs they have comes from a different person, or whether an AI is using your facial image to turn you into a proponent of a political party you massively disagree with. In all of these cases, what you feel, the reason why you're upset about it, is this feeling of denial of your individuality, I would say, the rights that you had in this. And historically, we've dealt with this through law, and then we dealt with this through technology. But what we really need is law and technology in coordination. We need the right technological tools and the right laws working together to get the type of result that we really want. I'm going to tell you now a little bit about some of the things we did at the Decade Center. One thing was a token gesture. Token gesture we did in parallel to the DLT ownership consultation of the two governments. We wanted to know, how do people who are not lawyers or technologists think about that? What do they feel? What is it really when they are interacting with one of these digital artifacts, where their preferences and intuitions are? And the best way to do this is to make them having an NFT. So what we did was to set up our city center. It is a city center. I would still say university hall. We invited people in who walked past, and we told them, choose a color that is different from any color that we already have. And with the work of some artists in the back, we will create an NFT for you. The precise framework I'm not going to go into. This is essentially what we did with them. It's a little bit complicated. So you have to present a color to generate the artwork. Your camera triggers that, decides this is really a new color. On that basis, there's an artwork created, that goes back to the screen. Eventually you see it. Then you have to finally mint it. And eventually it will be as an artwork in your wallet. All of these steps, uncommon for most people, but they were quite willing to engage with us. I was quite pleased to get so many folks coming in and actually working through that process. Here's one example. That's the color the artist had chosen, and that is the works that you get from it. And it's a unique. It really is an NFT. And then we ask people, what do you want to do with it? What are the things that are really important for you that you don't want to give up? What are the things you would like to give up? And we try to evaluate some of that and then feed it back into the legislative process. If you remember, ownership of digital assets in England essentially trusts the courts with some minimal steer of the legislator. In Scotland, legislate in more detail. But for us, the overarching theme here really was the in-principle ownership is something people value. They really understood, even though they were not lawyers or in any way experts, the difference between owning this thing and just having a license to use it. That was a very, very strong message that we got. We also got, in line with the English consultation, not the legislative proposal, but the consultation, a clear difference between effective control and possession. So the feeling that they possessed that image, provided that no one else could interfere with it. And that was, they would use the term possession, which legally speaking isn't correct, but that is how they felt about it. What made it theirs was that they could exclude others from grabbing it, essentially. And in that context, transferability was diagnostic. So many of them said, yeah, we would like to be able to trade it, to sell it, to exchange it, but it was not universally seen as the one important aspect that had to be there. Many of them said, we just want to have it. It's enough that I can have it and no one else. I want to show it to people. I want to demonstrate it. A little bit like a medal that documents that you have achieved something. And as long as I can do this and prove that it was me who achieved that, who went through all this complicated work, that's all I want. So this was, again, partly what we fed back to the government. Don't use transferability as a definition. Yes, for Bitcoin and other things, it will be very important, but it is not a universally recognized aspect. Effective control, yes, that's exactly right. What you need to have is to give people the right to control the thing at the exclusion of others. And yes, it is actually a good idea to give them ownership. Having said that, quite a lot of people always felt that it wasn't enough to talk about their ownership or the exchange of ownership. It was a thing you could do with it, the communal aspect that you got out of it, the ability to discuss it with others, to have a selection or a gallery, a combination of works. And as a result, we went one step further, and in Oregon, we tried to play around with this notion of using your work to create something new, where you still have a say, but it is a limited say. It is the equivalent of a quilt, I would say. And quilting as a traditional art form, I think, very much expresses this idea. You contribute your part. Everyone knows that that was the part that you contributed. You have a say in how the eventual quilt will be used, but you won't have a universal say. And once your part is actually combined with the rest of the quilt, you may also not have the right to take it away again. If you fall out with your fellow quilters a year after the event and you say, well, I quite like to have my square back, your typical answer historically would be no. You donated it, you participated in it. You have still the right in it, but it is now a right that adheres to all the other parts and all the other makers. So we tried to replicate that. That is still ongoing work. People choose the squares that they want. They can then reuse them into something bigger. This can form patterns. So there are parts that really allow you to build them in such a way that they form then a circle or quadrangle, or they can be just, again, as many quilts, a mix of different parts. And again, the question then becomes, what is it that you get out of that? What is it that you want from this? And again, some of the sort of insights that we get is control matters, as does sharing. So they want to have the ability to work with others. They are quite happy with losing parts of their rights when they combine it in that way. The fear of AI, the fear that the cumulative work or the individual parts can be now copied from part of an income stream of one of the big companies. Provenance accountability, being able to prove that they were the ones who contributed that specific piece, was extremely important for them. And in a way, also fitting our recommendations that we then put in, an opt-out system is fine. So you can have a system where your digital work will be used by an AI unless you say otherwise. But there have to be universally agreed standards on how to opt out, and B, really, really harsh sanctions for anyone who violates them. And that's, again, for me, where the law comes in. That is the traditional legal model to think about theft, which I still think fits that extremely well. Aquila became, mainly on the informatics side, the translation of this into a usable tool developed together with Adobe. They essentially developed this visual attribution here as the nice equivalent of a QR code. It tells everyone in the supply chain this work comes from this specific artist, this specific person, and then you can add metadata that will, through blockchain technology, through a smart contract, ensure that if it is used for training AI, the right amount of compensation will flow back to you. Won't be a lot, to be honest, but it, again, helps people to understand and accept the rights that they grant when they publish and do not opt out. This is for images, which makes it sort of easier. Text is much, much more problematic. Sound is much more problematic. But at least for text, we can definitely see that if you have the right type of content provenance standards, we've used C2PA, then we can use the NFT idea, not in the way they had originally seen it as a new form of making art, but simply as a mechanism to enforce existing rights in a system that allows ownership rights and attribution. And it allows also to get financial compensation, but more importantly, it allows you to enforce your moral rights, and in particular, the one to be named as a contributor. So that is essentially what we did there. Now, Aquila works if everyone wants to play along, ultimately. It works for those big AI companies who want your material and they want to abide by the laws. If you have that convergence, a blockchain-based system is actually doing its job. But what do you do if it doesn't? If you have people who are willing to scrape data on the internet, use it for training of AIs, and are not interested necessarily in abiding by the law. Well, if you do that, you need to technologically collective action, or exactly technologically collective action. And there are systems out there that do this. And one part of our work was to find out what is the legal status of that alternative. What can you do if goodwill alone and the ability to show that you are complying with the law is not enough to satisfy your desires? Nightshade, developed by the University of Chicago, is one of these systems, the one that we looked in particular because I felt that it forms a good counterpart to what we did with Oregon and other systems that allow lawful use of technology. What it essentially does is to poison the training system of a traditional AI. If you nightshade your image, then there won't be a difference in the visual perception for you as a human, but the AI is going to see something very, very different. So you can see at the top the clean model, the thing that the AI should learn or would learn in a normal system. And then depending on how many poisonous samples you get, what it actually does learn. So it learns that the dog is a cat, the car is a cow, the handbag is a toaster. Fantasy art becomes pointillism, the cartoon becomes impressionism. I never quite thought that that one works particularly well. To me, they look pretty much the same, but concept art and abstract art. So it essentially learns the wrong things from you. You are poisoning your system just in the right way. And what is important here is the more people choose the same misleading template, the same misleading shade, the more efficient it works. And that gets us back to the digital ledger technology, the blockchain environment, the ability to coordinate between you how you want to poison your art is making it massively more efficient. What do we think as lawyers about that? Well, we know what, actually flicking quickly through these, should mention this. They say that used responsibly, Nightshade can help deter model trainers who disregard copyright opt-out lists and do not scrape robotext directives. So again, these are the people who do not want to abide by, excuse me, the standard that we developed for origin attribution before. But how you ensure that the people are going to use it responsibly, that becomes exactly the problem. How can I, as a University of Chicago, make sure that only responsible uses of that technology are made? Again, I'm not going through that. They also say that it will not affect large language models, non-generative AI systems like medical images, which is nice. But again, I'm not entirely sure how they can prove or assure that. But that is the way how they describe the system. And when you go to the FAQ, they have a sort of more discursive element there. And one question is, what does the law say? Does the law allow us to do this? And the answer you get is, I'm not a lawyer, so I can have talked to plenty of lawyers. None of them have any concerns about legality of me creating Nightshade or anyone using Nightshade to produce their own art. One accurate analogy for using Nightshade is like putting a hot sauce in your lunch that is clearly labeled, do not eat, scrape. Someone's stealing your food and is doing so against your express wishes. And if they get sick from the hot sauce, you are not liable. I wonder if he was the lawyer whom they asked. Because this, to me, sounds pretty much like Left Home Alone. The original photo talk also had a rather bad image from that brilliant film with Rutger Hauer, where he plays a blind samurai and gets this really, really hot sauce from some mischievous Mexican in a bodega. And again, the idea is, no, the mere fact that you put hot sauce on it or don't use it does not necessarily give you full rights to impose whatever negative consequences you want. That's what our intuition tells us, I think. And there is something in that intuition that deserves to be either implemented through legislative change or might even be available to you anyway. But when we looked at it more carefully, we realized that was how we started, trying to trace the interactions between different laws to find out what exactly is going on here. Not just some lawyer I asked who might be really, really good for inheritance law, but might not have the right competence in criminal law. These were the different facts that we thought we need to deal with when we try to ascertain, is that legal or not? And then Amanda, number two of the co-workers that I mentioned at the beginning, at one point said, Burkhard, you are really, really overthinking this. Look at what the CMA, the Copyright Misuse Act, said in the original draft and now. And in the amended offenses, unauthorized acts with intent to impair with recklessness as to impairing operating a computer. fall under this offense. But this is not what the Nightshade user is doing. There is no duty to talk lawfully, truthfully to people. There is no duty as an artist to create works in such a way that AIs can easily scrape them, as long as you don't have entered into a contract with AI. Because this is purely passive, you are making changes to your system. What the other side then does with it, even if you find it uncomfortable, unfortunately falls outside the act. And I think by now this is the correct understanding of both the UK and the US law, that this behavior alone, if it is done individually by the artist, is not violating any laws. Rico rolled, could that be Rico? Sounds a little bit like it. You have a really nice model here. If you give us money, you can keep it. But again, because it is not the University of Chicago that makes this claim, but each individual actor, I do not think a RICO lawsuit against Chicago would work, and they don't work against the individuals because they're individuals and not doing it collectively. Here we see really the benefits of using a decentralized system like Nightshade versus a centralized one where the developer remains in charge and you do get a responsibility gap. I played around with other ways to get them. I tried my best. Conspiracy theory under English law, there are 4 elements: combination or agreement between 2 or more individuals, an intent to injure, pursuant which combination or agreement and with that intention certain acts are carried out, resulting in loss and damage to the claimant. I don't think this cuts it either, because again, the intention is not to injure, the intention is to get the rightful amount of money for your work, and that doesn't quite work. It is not in itself an unlawful act. Now, English law also has the lawful mean conspiracy. And that is the sort of thing I'm sort of hanging on to at the moment. Conspiracies can be unlawful even if the individual steps that you take are lawful. And that would, for instance, be a conspiracy amongst competitors of a business to individually write negative Yelp reviews, even if they are a perfectly good company. So the agreement to do something that is individually lawful, writing a bad Yelp review, by the fact that they coordinate it, becomes something unlawful. And here we then really have to ask ourselves, what is the role of the University of Chicago, of the one that provides the technology? To what an extent do they still allow this type of agreement, where they might fall within the scope of a lawful means conspiracy? And to what extent do they really just say, you take it and you do with it whatever you want? To me, and I think that is a point where I will stop very soon, is the following. Should we behave differently when our actions train AIs? If we know that what we are doing will have consequences on a popular used AI system. The example I tend to give is I'm standing in front of a traffic light. It is 3 o'clock in the morning on Lothian Road. I can look to the left, I can look to the right. I see there's absolutely no car anyway. Even though the traffic light is red, I will walk through, and most other adults will as well. Some Germans, I know, stand still and wait till it gets green, but that is not normal behavior. And it didn't even take me 30 years in the UK to find that out. It only took about 3 months. That's fine. But if the same situation happens, obviously not at 3 o'clock in the morning, but say at 3 o'clock in the afternoon, still there is absolutely no car. It is perfectly safe. But I see there is a child on the other side of the road looking at me. My instinctive reaction becomes, I stand still. I don't want to be a bad example. It will be just one very, very small piece of negative training that the child gets, but I do feel responsible for my actions. I know I'm observed, and therefore I behave in slightly different ways. And that, I think, is one of the things we have to consider here. To what an extent is the mere fact that our actions are impacting on the AI in the DLT system here through combination of individually lawful but combined harmful actions a problem. And that is where I want to potentially reinvent a little bit of Habermas. The story I just told you was a story. I could tell it to you. I hope from reading your faces, most of you got it, which is great. I sometimes do this with my undergraduate students, and the reaction is, what on earth is he talking about? But that seems to have reached its intended audience. If we now have a vote on how do we behave with AIs, I would have reasonable confidence that whatever we decide will be supported not just by a majority, but by an informed majority. And the fact that we went through a discourse where I didn't take any role at the beginning that said I won't hear certain contributions, I won't hear certain people speaking, that fact alone, together with any of us contributing to that question, gives me reassurance that our result can be justified. Can be justified. Not as the right one, not as the best one. That's the problem, I think, of distributed ledger technologies. They want the right result or the best result, or what they get is the one where most people are happy with, but not necessarily the one that is best justifiable. I think a Habermasian context, where we say, if you can demonstrate that you know what you're actually talking about, if you had listened to the discussion, if you have participated, you should get rewarded and get the right to then contribute also to the outcome. There are systems that do that. I'm just giving you 4 here that are decentralized ledger technologies that are using AI in different formats: Steemit, Hive, DTube, and Mind. Steemit is essentially an X equivalent, Hive as well. DTube is a Facebook equivalent, as is Mind. They play around with different ways of introducing the audience as stakeholders in that decision-making process. I'm not advocating them as role models, because they aren't. They really, really aren't. What they do is dreadful in many other ways, but the underlying idea makes sense. Rewarding your participants, the users and the nodes, in a system that enforces certain types of rights, certain types of claims, including a claim to be able to participate if you have done something else before, is, I think, exactly where we should be going. It shouldn't just be how much money were you willing to stake on this, even though that can be an element. It shows how committed someone is, but the mere fact that you have lots of money flying around doesn't necessarily give you the best say in something. But if you can combine it with something that says you can show that you have a good track record in making these suggestions, most of your past claims were also validated. If you can show that you worked through certain types of material, if you can show that you are treating both sides fairly, all things that in principle can be measured to a certain degree and incorporated into a smart contract, I would say we are getting to something where we combine the advantages of having a distributed system and the advantages of sometimes using AI with something that gets closer to what the Digital Services Act tries to achieve, and even on a bigger scale in Europe, the European Human Rights Framework tries to achieve, that is having a responsible and democratic distribution of rights and responsibilities. And with that, I'm finished. Thank you.